I now call the next case on the docket. Case number 118944 in the matter of Tammy E. Kurth.
May it please the Court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. Mr. Chief Justice, may I have 2 minutes for rebuttal?
2 minutes is granted.
Thank you, Your Honor. As you all know, this is an original proceeding in attorney discipline. There are 3 cases. 2 of the cases were based upon a revoked diversion, and in that diversion there was a stipulation of violations of KRPC 1.3, 1.4, 1.5, and 1.16, and those were affirmed by the hearing panel. The misconduct in those cases arose after the respondents suffered a significant personal tragedy and some health issues. The 3rd case involved the filing of some papers on behalf of suits that she brought on behalf of herself and her husband. There was a hearing that was originally set in November of 2015, but that hearing was continued because the Office of the Disciplinary Administrator filed a petition for an independent health evaluation. That petition was filed in March. In March, this court granted the petition, and the evaluation was completed in July of 2016. At that time, the evaluator concluded that the respondent was mentally and emotionally capable of managing the responsibilities of a law practice. The hearing was conducted in August of 2017, and the final hearing report was issued in February of 2018. At the hearing, the respondent testified that she's been treated for depression and anxiety for over 12 years. She also has a shoulder affliction. At that time, the time of the hearing, she had been diagnosed again with PTSD and had begun some treatment for that. Her secondary treating physician testified that he met her around 2009, and at that time he diagnosed her with a mood disorder that consisted of major depression, PTSD, chronic depression, panic disorder, and chronic pain-related issues. He started treating her in 2009, and at the time of the hearing, she was being prescribed Seroquel for mood depression and mood swings, Dilaudid, which is a high-powered, potent opioid. She's prescribed 8 milligrams every 4 hours as needed. She had a muscle relaxer prescription, a beta blocker, and also Xanax. During the hearing, the respondent testified that she had taken a Xanax and 3 sleeping pills the night before. She had taken 2 Dilaudid before the hearing, and an Adderall before the hearing, and then another Adderall during the break. At the hearing, her prescribing physician testified that he just had recently started giving her the Dilaudid because of a self-report that her pain was not being adequately managed. Prior to that, she had been on oxycodone, a 20 milligram prescription, or 20 milligram dosage 4 times a day. They were attempting to taper her off of the Xanax because of issues with the central nervous system. She had been found unconscious at least 1 time, that being in October of 2015. The doctor testified that Adderall, Xanax, and Dilaudid are all highly addictive substances, and that the Dilaudid was being prescribed at a very high dose. He testified that their hopes were that eventually she would get her pain managed and they would be able to taper her off of all of these medications. This isn't a situation that she could just stop. It's going to be a process. He said that after everything that she had been through, that he did not believe that she was capable of practicing law. He hoped that she would regain the capacity to practice law, but, quote, today is not the day.
Counsel, was that testimony from the doctor unexpected to you, that he was going to testify that she was not able to practice at that point?
It was.
Okay, because I thought it conflicted with what you originally anticipated, as you said in your opening statement. Okay,
it was.
Okay.
Respondents' counsel argued before the panel that it was not for the panel to make a determination of whether or not the respondent was competent to practice. A majority of the panel concluded that it was part of their responsibilities.
I'm sorry, I'm going to interrupt you again.
Sure.
There wasn't a an ethics violation of failure to be competent alleged, was there?
No.
Okay. And the last couple of the last complaint or that you, as you characterized it, about the filing of pleadings in the cases for herself and her spouse, those were not found to be meritorious by the panel, correct?
They did not find that the allegations on those two were the failure to cooperate, and they did not find those.
Okay.
Yes.
Thank you.
The panel determined that it was part of their authority to determine competency because of the duty to protect the public. And in coming to that conclusion, they used kind of the totality of the situation. They used the pleadings that were filed. They used the respondent's interaction during the hearing, and Dr. Geenans, who was the treating physician that testified that based upon her prescription regimen, she was not competent.
Can I back you up again on
Sure.
that? I think that precision and language here would be really beneficial. It always is, but I think especially here. I mean, I just asked you about whether there was an allegation of a lack of competence under the ethics code, and you said no, there was not. So when the panel and you speak of competence in the context you just mentioned it, you're really talking about capacity to practice, right? Not competence in the sort of, in the sense that you have the legal skills to do a specific job.
I would 100% agree with that.
Okay, so you're really talking about capacity, and isn't that really what's addressed by 220 versus the ethics code? I mean, you did attempt a 220 proceeding. Right. In fact, you in essence started one. You asked our permission. You wanted an order for her to undergo an evaluation. She did that. And it had the result it had at that time. That procedure is always available, right? Even in the middle of a disciplinary proceeding, you could short circuit, as you did here earlier, and attempt that again, right?
Well, I did not feel that it would be appropriate to come back to you when I had this evaluation that was conducted over a period of time that said
but
that
it was a full 2 years before the hearing, right?
That she was competent. And,
right.
And there hadn't been any subsequent complaints filed that would indicate to us that there was something still going on.
But at the time that it's is it Geenans? Geenans testified at the panel hearing, then you did have testimony that might have supported a 220 petition again, right?
Probably yes.
Okay, so I just want to differentiate, if you can, as best you can, when we talk about this, between competence, as we think of it in the sense of legal ethics code, and capacity as we think of it in 220. Because it sounds to me like what the panel did here was consider capacity in arriving at its recommendation. And that may or may not be appropriate. I guess my final question on this to you is, does it matter? Because even if we put that aside, there may be justifications for recommendation. So I'd like to hear you address that at some point in your remarks.
I'm not sure I followed that last.
I'm sorry if I'm confusing you. I think that the parties today, it appears to me from the pleadings that have been filed, but the parties today are disputing whether the panel overstepped its authority and basically engaged in a 220 proceeding without any of the due process afforded a respondent in such a proceeding. She was getting lots of other due process, but not a 220 proceeding. And that's what everybody's fighting about. And now that we've clarified terms, and you've agreed with me that you think that in that context the panel was talking about capacity rather than competence, I'm asking you, why does it matter if the panel did that wrong? If they were overstepping on capacity, why does it matter? Because they were still there to determine whether there were ethics violations or whether the facts were supported by clear and convincing evidence, whether there were ethics violations as a result. Neither of those things has been contested. The only thing that's being contested here, even though we're calling it a contested proceeding, is the sanction, which is like every other uncontested disciplinary case we have. So I want you to address whether we need to rule upon the panel's authority, the extent of its authority to determine capacity in a disciplinary proceeding if their ultimate recommendation is up to us anyway. We can put that aside if we think it was appropriate and rule upon the facts and the law that have not been contested.
I think it doesn't necessarily matter in this case. I think what the panel was talking about, they were talking about they observed cognitive dulling and they observed other things. And maybe the use of competence was an inartful word. But I do believe that the panel's conclusion that they have an obligation to determine whether someone either is competent or has capacity is within their bounds. And at the end of the day, in order to protect the public, making a finding that this person just shouldn't be practicing law until they demonstrate whatever mechanism we use to get there is really the bottom line here. And that's why I asked for a 30-day suspension, a 6-month suspension with the 219, because I really think that the important thing is the reinstatement hearing, to confirm that she's been able to taper off of her drugs, to confirm that she's continuing all of her various treatments. She's doing talk therapy. They wanted to do this light therapy that is supposed to be effective with folks that have suffered significant trauma, which she has. And at this point, we just don't know where we're at in the process. And perhaps a 220 would have been the better process. I again, didn't think that it was appropriate when I had
The previous
and
evaluation.
we should have
Let
stopped
me
there.
just try to short circuit my question. We would have the ability, this court would have the ability to order a suspension and a reinstatement hearing regardless of the capacity testimony, just because of the violations that have been not stipulated to, but found and not contested.
Right. Unfortunately, the cases that there's the stipulation really are an abandonment of clients and the abandonment of practice because of all of the personal tragedies that she was going through. So I think that conduct supports some sort of a suspension.
That's what I thought.
Yeah.
I thought that would be your argument, and that's why I wonder if all of this fighting about what was in essence a capacity finding by the panel is just not going to end up necessarily relevant to our decision. I was just trying to get you back to the basics, because I think every day that we sit in disciplinary cases, we decide sanctions, and we independently evaluate whether the panel's recommendation is sound or not, and what the court believes is appropriate in the case. And that's really what the bottom line is here, because the facts are not disputed and the conclusion of law that there are certain violations is not disputed. So I was trying to focus us on what's really at issue today, because I don't think we need to necessarily use this case as a vehicle to define panel authority when they're confronted with an ethics case, as opposed to what's going on in a 220 capacity proceeding.
I agree. Yes, I think a panel should always have the ability, just like a jury or a trier of fact or anyone, to observe demeanor of witnesses, to assess credibility. I think that is part of it. And I think as lawyers sitting on a hearing panel, you know when you're observing conduct that isn't beneficial to representing clients.
Do you think those capacity observations, that's what I'll shorthand it as, made a difference in the panel's recommendation?
I do.
And so then, don't we have to decide whether or not it was proper for the panel to consider those things?
No, I don't.
Maybe your fallback argument is, look, the violations by themselves justify either the panel's recommendation or your recommendation.
Correct.
But that's not the situation we're in. We're in a situation where the panel's made recommendations. You're making recommendations, and both the panel and, as I understand it, the disciplinary administrator's office concede that your recommendations are premised in part on conduct that is not a rule violation, has not been found to be a rule violation.
I don't know if I necessarily agree with that. My recommendation was based upon the stipulation of the rule violations and what would normally happen. The 219 aspect of it was to ensure that when she comes back to the practice, that she is capable of handling the stresses of
Well, let me
practice.
shorthand it this way. I understood your statements to mean, in essence, that the panel and the disciplinary administrator's office have a heightened recommendation based on things that they observed or you observed at the hearing. Those are the capacity observations, or you called it cognitive doling, or some of these other things.
The way I read the panel report was that factored into their recommending 2 years. That's just how I interpret it. And I think that it is appropriate for a panel to be able to make recommendations based upon the totality of everything, the record, the evidence that's presented, and then the presentation at the panel.
Let me put it to you this way. If you have a case in which violations like the violations here are demonstrated, and it's uncontested, would you recommend a suspension?
I would.
And if during the proceedings, part of the explanation for the behavior of the lawyer that led to those violations was some sort of physical or mental health concern, including, as we see in so many cases, substance abuse or something like that, would you also suggest a 219 hearing before the lawyer was readmitted to practice?
I would.
Okay, that's my point. If that's the bottom line, and the panel additionally said we think there's incapacity demonstrated by behavior today, that may or may not matter, because this court has the ability and the power under our rules to determine sanction and whether a 219 is recommended or required for readmission with or without that capacity testimony.
Mm-hmm. Yes.
Thank you.
Do we have any further questions? We've taken a lot of your time with our questions. Do you need 60 seconds to wrap up?
I do not. I just, again, am reaffirming my recommendation for a 6-month suspension with a 219 hearing.
All right. Thank you, counsel.
Excuse me. May it please the court, John Ambrosio on behalf of the respondent. I apparently don't need to use my notes because my argument is going to go toward the questions that I've asked. Number one, the discipline, the activity in this case that led to the hearing would never have resulted in a suspension under anything under this God's earth. It wouldn't have ended that way. They would not have, if the conduct would require a suspension, they never would have offered a diversion and granted my client a diversion. So what happened here, she gets a diversion, she's not handling the diversion very well, and I'm not being critical of my colleague, but the diversion is then revoked and she faces a hearing. At that time, your petition to have her examined and a psychological evaluation occurs. She passes the psychological evaluation with flying colors. We have a hearing with the same activity that was described, that she was granted a diversion, and now, because the panel doesn't like her appearance or is off-put because of her odd personality, they recommend suspension. So she's being punished because she looks different, and she's being punished because she acts differently than everybody else. And that's exactly what happened here. The psychologist indicated she had the capacity. The doctor who prescribed the pills, who has been dealing with her for 12 years, indicated, I'm unsure if she should be practicing law with that type of medication. But he didn't offer anything.
His testimony was, we're trying to taper it off so she is able to practice law. And
Absolutely
that's not,
correct.
That's not, I'm not sure. That's equivalent to not today. I disagree with your characterization of the testimony, Mr. Ambrosio.
Well, and it caught me by surprise when that question was asked, because I had asked him
Surprise or
before.
no, it is what it is, right? And
Most
the
of the
testimony
time.
was, we're
Correct.
trying to taper
You're
her
absolutely
off.
correct. That was the testimony.
So she
And-
cannot be simultaneously fit to practice and unfit to practice
No.
in a capacity sense. I just want to zero
You're
in on this
absolutely
one
correct.
piece of testimony. Okay.
Well, I hate to admit it, you're absolutely correct. But what happened here is one doctor who does a terrific evaluation and looks at everything says she's able to practice. Another doctor says, I'm worried because of the medication. And the panel then jumps and said, the best thing to do here is, we can't decide capacity. We don't like the way she looks. We don't like the way she appears. Ergo,
Counsel,
we're going to suspend her.
You said that twice now. The panel took its
I
action.
want to make sure I'm heard.
Because I heard you, because it didn't like the way she looks and it didn't like her odd personality. I think
Correct.
those were your words. Where can you point us in this record? What's the best facts in the record that supports that statement that you just made?
Dr. Huddleston's report that says there's nothing wrong with this woman's ability to practice law, that she has the capacity to practice law. And the panel, in the face of that, decided she didn't have the capacity.
Your statement is nothing, how do I say this? I mean, you're saying it's implied by the panel's ruling.
Absolutely.
There's nothing in the panel's decision that would lead a person to
Absolutely
think.
right.
Okay.
But that's what they're saying. That's why they did this.
Well, but I'm asking.
And I'm telling you, that's what I think.
Okay. But not based on anything concrete other than just the implicit, what other possible reason could there be?
They weren't so silly to put that in the report, Your Honor. They weren't so silly to put that in the report.
You're drawing a deduction.
I-
You're making a deduction.
Correct. And that's what happened here. This did not give rise to the type of discipline that was meted out. They asked and gave her a diversion. And what happened here, she passes with flying colors, and I appreciate the fact, and my colleague and I talked about, do you do another psychological evaluation or not? And I hear what she's saying, and I respect that opinion. And we were in agony about what to do in this case, and I am convinced that Ms. Marsh, is absolutely correct that they made this decision based on capacity. And although she indicated she would have gone along with that discipline, it's because they didn't like her capacity.
Mr. Ambrosio, I'm sure you don't agree with me, though, that no matter what they did or why they did it, we have the ability and power at this level to disregard.
Absolutely, because I've said that every time when I come up here. With the permission of the court, my client would like to address the court.
Before you do that, counsel, what are you asking us to do?
I am saying that the discipline that should be meted out should be a published censure, although I argued for an IA below. A published censure based on her conduct, based on her activity, based on the violations, Your Honor.
All right, thank you,
Thank
counsel.
you. May my client
Yes.
address the court.
Yes.
Please, don't
Yes.
yell like I did, please.
Thanks, Seth.
Go ahead.
Excuse me. If I might, just so that you know, it has not been my year medically. Just in summary, I just want you to know that any appearance of incapacity, I had just recently experienced what's called a rectal prolapse and averted surgery, but it was quite serious, and I'm still quite ill, frankly, and so if you will just take that into consideration, I would appreciate it. Also in May, and I'm still recovering from that, I had double pneumonia and then acquired a staph infection, courtesy of Southwest Medical Center. Had to be flown to Wichita in order to have surgery to scrape it from my lungs because my body was not immunized to it. So it has not been a good year. And here I've already wasted that much time. I just wanted you to know, as to capacity, why I may appear a little less than articulate than I normally would. Thank you. What I'd like to do is just very, very quickly, tell you the truth, the facts, in the utmost honorable and authentic manner. Because my 33-year-old adult daughter was dying at Via Christi in Wichita, I was without choice, to abrupt departure from my 30-year practice to be with her in death. I can read my writing here. All clients, and I had approximately 200 open files at any given time. Practicing in Oklahoma and Kansas, about half and half, were notified that they would need to retain other counsel and that billing would occur as soon as possible, but at some unknown time. As fate had it, I had a 2+ year secretary who was the one I had dreamed of for 30 years, and she quit abruptly a couple of months before this development with my daughter's life flight, August 13th of 2011. So that compounded my situation with the billing issues. I had no ability to even operate the billing program. But in any event, she was in death and dying, and it helps me to use those catchphrases. For 4 months. Sorry. And
Take a deep breath. You're doing fine.
she was life flighted on August 13th, 2011, and died December 6th of 2011. And it was not until the spring, frankly, of 2012 that I was able to beg the 2+ year wondrous secretary back to help me to complete billing and wind down close files. And so the clients had to wait, for an exceedingly, unacceptably long time. But in my mind, and at this time, it was unavoidable. I knew of no other way, in which to address it than what I did. That was the basis for the complaints. Coincidentally, I think not. 2 of the entirety of my caseload in clients persisted with wanting me to assist them despite my circumstances. And I just couldn't say no and continued to help. It happened to be those 2 who filed complaints as to their fees and refunds of unused retainers, if any. And that's what the basis of the complaints was. Those are the complaints. Quickly. She had borderline personality disorder, and she drank herself to death in 2 years after having her last healthy 6th child. Bear with me. Can't even read my own writing.
Just roll. You're okay.
When I walked out of the office on August 13th, I knew, as only a mother does, that she would be facing death because she had had one life flight before that. And I knew that we had turned a corner. And I didn't know how long I'd be gone, but I knew I'd be gone, with her. I indeed spent, until her death, physically, all of the time with her. I came back occasionally because I have another child who was then a minor, but I'm getting off track here.
Why don't you tell them about the drug, that you've cut back on the drugs?
Oh, I've got that in here. I really appreciate you bearing with me. And there is some organization to this. I thank you for, let's just go to that and then we'll come back. To my dismay, at the hearing held a year ago, this last August, before the panel, they did not seem really too interested at all in the diversion, whether or not I had violated it, if so, in what respects. They were basically completely preoccupied with the use of opioids. And, at that time, as we all know, still yet, it is a very, very serious health, condition for our country. It couldn't be, more serious. And I don't know how long it'll be that serious, but it is, and it was then. And they focused on that, nearly entirely, in my perception. I'd like to speak to that if I could just tell the court what's going on here. Since '99, I had a little pain in my right scapula area when I'd sit at the desktop. It seemed a little bit and get good to go. During Brandy's death and dying, it took on a new life during that 4-month period. And from there, which was December 6th when she died of 2011, it has worsened progressively, in my perception as a patient. And I have been to the Florida Spine Institute, 8 to 10 Kansas specialists. I've had MRIs, CAT scans, epidurals, spinal blocks, and no diagnosis to date. Doug Geenans was the psychiatrist who was spoken about. He came out to help try to salvage our mental health system in Seward County, unsuccessfully ultimately, but I met him there and have been professionally involved with him since. He was the one that prescribed the pain medication along the way. We'd go up, we'd go down, we'd try to stay down. We just tried to do what we could to keep it minimized. But it got so bad that I just needed it for functioning, just for daily functioning. He decided, as a psychiatrist, I don't prescribe opioids anymore. As of January of this year, no more opioids for his patients. I didn't think too much of it, but I had no more after January, so I just quit. Didn't take any more until June. And I was having such suffering that I just couldn't tolerate the pain and had a trip planned to Grandchildren Fargo, just had to have it. So since then I've had some oxycodone on a limited basis. But I have no addiction. It's really not an issue. It's for pain and pain only. I don't believe that it affects my capacity to practice in any significant way. Practiced for 30 years, and I'm certainly positioned such that I know, when I need to be practicing, meeting with clients, and when I don't, and can temper my use of medication, appropriately without any difficulty. It is what it is. But I need a diagnosis and treatment. But I'm sure God's going to bless me with that soon. I'd like to cover just a few things, if I might.
I'll give you about 60 seconds of latitude if you can.
Close it. Why don't you close? Take a deep breath and close it.
Okay. I did not violate the diversion agreement. The diversion agreement called for a monitor if I practiced. There were 2 lawsuits that were meritorious. I've never sued anybody in my life, but it took over 2 years for this matter to be investigated, and I had to file these 2 lawsuits. I was told by Ms. Knowles that I was in violation without a monitor, even though they were pro se matters. And even though I designated my husband as his own pro se counsel. Those 2 matters were the reason, ultimately, that the diversion was revoked. And I just couldn't offer in more good faith that Ms. Knoll and McDonald both tried to find monitor. I have a nephew who's an attorney who committed to monitor and then backed out. We just were in a position where we had none available, but I didn't think one that applied to pro se matters in any event. But ultimately, I did nothing. Nothing. Didn't appear, didn't file anything. One pleading, which was pre-approved by Ann with Ms. Knowles' consent, period. And I was revoked in March 2015, unbeknownst to me, for a year and a half later, when they asked for the mental health evaluation. So, I think he wants me to stop.
Well, just so I'm clear, it's your statement to us today that you have the legal ability and the mental capacity to continue practicing law, and that leads you to ask for a published censure. Is that right?
You can,
Yes.
you can answer.
What is, I'm sorry. His wife has been ill, and
Understand?
we haven't visited to perhaps the keen extent.
Just answer the chief's question. Yes.
Yes.
All right.
May I please, I lost my train of thought, if you bear with me. It's so important. I had one thing that I needed to tell you, and it went away. If you'll give me a moment. I have had no income for 6 years. I was the sole support of our household. I'm now involved in the third foreclosure on our home. We've liquidated all of our assets. It's just a terrible situation, and one that I had no control over at any time. I did the very best I could. I don't believe I violated any of the terms of the diversion. But everybody tried their best. We all worked together. And this is where we find ourselves.
All right. Thank you, counsel.
Thank you. I'm sorry for taking longer than I should.
That's all
You should
right.
take that with you, please.
I'll do that. Thank you.
Well, thank you both.
I just want to make sure that the exchange I had with Justice Beyer was clear. We knew going in of her personal tragedies, which is why we tried to use the diversion process and didn't just automatically recommend a suspension. If it were a case that we did not have that back history and that understanding, that there were issues that maybe could be resolved through treatment and KLAP support and some other things, we wouldn't have used the diversion process. We would have gone straight to a panel with the recommendation.
I have another question.
Sure.
Ms. Kurth said that she did not violate the diversion by filing the two lawsuits on behalf of herself and her husband, or maybe just on behalf of herself with her husband designated pro se. Is that the only diversion violation that ended up having the diversion revoked?
No.
Okay.
And let me start with the filing of the pleadings. She's maintained that Ms. McDonald and I both reviewed those. I was not made aware that those pleadings were even in existence until well after the diversion had been signed. I saw those pleadings first when they came in the form of the complaint. I believe Ms. McDonald's testimony was that at some point in time she did see those pleadings, but she would not have recommended that she file at least the handwritten portion, that the typed portion probably was okay, and I would agree with that. She was to attend additional CLE hours, which she did not do. That's page 6 of the diversion. She was supposed to submit to the fee dispute committee, which had actually been disbanded, so that did not count against her. She was supposed to engage in continuous KLAP monitoring, which is different than having the practice supervisor and all of that stuff. And Ms. McDonald testified that there had been a period of time that she was not in contact with KLAP. And then she was to get the person to supervisor, which we all tried, and we could not successfully find somebody.
So the practice supervisor element of it was broader than just the two lawsuits she filed. It was that she didn't have one, period.
Coming in, I'm sorry.
I'm just trying to understand the practice supervisor part. The non-compliance with the practice supervisor requirement, it doesn't have its only source in the two lawsuits. It has its source generally. There was no practice supervisor at any time.
Right, well.
But you excused that in part because of her region and difficulty finding
Correct.
one? Okay.
I mean, as she said, she had a family member that originally stepped up and then declined. I know Ms. McDonald, I know I reached out to people, and for whatever reason, there's a variety of reasons why someone doesn't want to take this responsibility on, and we just couldn't find anybody. And I just want to kind of address the difference between the KLAP monitor and the practice supervisor. Yeah. KLAP doesn't like having the same person doing that because they have different responsibilities and different reporting requirements. And so, and it was part of the diversion. The practice supervisor was part of the diversion to hopefully prevent those handwritten pleadings from happening again to create more issues. And so my hope was that we would have somebody that would just review things before she filed them and she wouldn't have subsequent issues.
Any further presentation?
I do not.
Any more questions? All right, thank you, counsel. I thank all three of you for your arguments this morning. Court will take this matter under advisement. We now